Hi, I'm Jim Rill, Baker Botts, and it is my great honor today to have the opportunity to introduce Assistant Attorney General Makan Delrahim to this program. Makan was confirmed as Assistant Attorney General in September of this past year. Prior to that, he was Deputy Assistant to the President and Deputy White House Counsel. And prior to that was a partner in a prestigious international law firm. He was located in California. And prior to that, is a resume that doesn't stop. Prior to that, he was Deputy Assistant Attorney General for Antitrust from 2003 to 2005. And in that capacity at that time, he was very much involved in the enforcement and implementation of the Antitrust Division's activities in the international sphere. And I can say from personal experience, very effectively so involved in outreach to foreign governments when they were departing from global norms of antitrust. He's been on the President's Task Force for Intellectual Property. He was a member of the Antitrust Modernization Commission, a very influential member of the Antitrust Modernization Commission, and now, of course, is Assistant Attorney General for Antitrust, a job to which he comes as well prepared, better prepared than anyone. Now, that's the resume. 6 months in office, Makan has hit the ground running. There's absolutely no surprise, given the background and given his experience, given his activity before, to anyone that he should be so effective in such a relatively short period of time. In the international sphere, his speech at New York University made clear that the division, with the Antitrust Division in the Justice Department, were going to take a very active role in trying to foment global standards of the process and even substantive convergence, and call out when some of our sister nations depart significantly from these global standards, these recognized global standards. In a speech in University of Southern California in November, Makan articulated with clarity his policy views of balance in the intersection of antitrust and intellectual property in a way that I think is long time coming and really receives strong support from people who look for rational policies on the intersection of antitrust and intellectual property. In the litigation front, he's been very active, and regardless, without talking about the merits, how matters come out, his activity there is going to bring about clarity in various areas of antitrust. So what we have here is an Assistant Attorney General who is an extremely solid exponent of effective, rational antitrust enforcement and antitrust policy. We're fortunate to have him, so it's my great honor to introduce Assistant Attorney General Makan Delrahim.
Thank you so much, Jim. Thank you. Boy, don't I wish Jim was there speaking on the floor of the Senate maybe 10, 11 months ago when I was held up for 6 months saying all those great, nice words. Thank you so much, Jim. It's a great honor to be with you guys here this afternoon, and thanks to the organizers of this conference, and particularly to my friend Jim Rill for inviting me to speak today. As I look out from this lectern, see a lot of familiar faces, a lot of good friends, and I'm just humbled to be in your company to to discuss this area that I'm personally, many of you guys know, who I've known for 25 years in various branches of the government, have been interested in and I feel very passionate about. I don't think my views are a surprise to anybody who has known me in the policy arena, whether it was in the legislative branch or in the executive branch previously. I know all of you guys follow the developments in this area closely, and that you're likely aware of these views that I've shared recently in some of the speeches on the issue of the intersection of antitrust and intellectual property, first at USC last November, and more recently at University of Pennsylvania last month. And having provided a lot of detail on these policy views, I just thought it would be most useful to expand on the division's role, or the roles of the antitrust division when it comes to the issues of the intersection of antitrust and intellectual property. As I see it, the division wears two hats in this space. One is the hat of the competition advocate, and the other is the hat of the competition enforcer. And both are important, but they're distinct. As an agency with more than 125 years of experience observing and analyzing markets in this country, more than 300 lawyers who spend countless hours poring over business documents, interviewing executives in various industries, and another 50 or so PhD economists who are thought leaders in the field of competition, we're well positioned to consider what effect a given policy is likely to have on the U.S. market. Naturally, given our mission of protecting and promoting competition, as advocates for competition, we aim to bring our resources and experiences to bear in encouraging and advocating for policies that will incentivize innovation for the benefit of the American consumer. In our role as competition enforcer, we take action when we have sufficient evidence to suspect the existence of an anti-competitive restraint of trade that undermines our free markets, or when we determine that a proposed merger may substantially lessen competition in violation of the Clayton Act. In our enforcement role, we bring cases against conduct that has been outlawed by Congress, and we prove those cases in the U.S. courts. Both of these roles are important to the division's core mission of protecting and promoting competition, but they are distinct, to be sure. So in the interest of transparency, let me elaborate on how we carry out our dual roles in the areas of antitrust and IP, and then I'll highlight a few risks associated with conflating the division's advocacy and enforcement work in this area with the goal of trying to avoid much of that risk. In competition advocacy, there's a great deal of work that we do in that role. A primary method of advocacy is giving speeches by a lot of the leadership and the staff of the antitrust division. At conferences like this, allow us to share with the public in person, as well as on our website, where many of the division's speeches are published, our views about what conditions will make the market most dynamic, innovative, and competitive. Although we speak often about the application of the antitrust laws, our advocacy extends more broadly. For example, at USC, I addressed remedies in patent infringement litigation and described my concern that by denying injunctive relief to standard essential patent holders, except in the rare circumstances, courts in the U.S. run the risk of turning a FRAND commitment into a compulsory license. As a defender of competitive markets, I'm concerned that these patent law developments could have an unintended and harmful effect on dynamic competition by undermining important incentives to innovate and ultimately have the detrimental effect on U.S. consumers. Another advocacy position we have taken relates to how patent holders are held to their commitments to license on FRAND terms. At Penn last month, I noted the so-called unilateral patent holdup is not and should not be an antitrust problem. Where a patent holder has made commitments to license on particular terms, a contract theory is adequate and more appropriate to address the disputes that might arise regarding whether the patent holder has honored those commitments. The division will not hesitate to bring a sound antitrust case But as competition advocates, we must strive to ensure that we use the antitrust laws for their intended purposes, which is to address practices that harm competition. Using the antitrust laws to impugn a patent holder's efforts to enforce valid intellectual property rights risks undermining the dynamic competition we are charged with fostering. So when it comes to disputes that arise between IP holders and implementers regarding the scope of FRAND commitments, we advocate for the application of more appropriate theories other than the blunt instrument of antitrust law. A third topic I've addressed recently is the need for balanced patent policies in standard-setting organizations. As I and others at the division have said on many occasions, by allowing products designed and manufactured by many different firms to function together, interoperability standards create enormous value for consumers. But standard setting only works, and consumers only reap the benefits of innovative and interoperable products when both patent holders and patent implementers have the incentive to participate in that process. To that end, I've encouraged standard-setting organizations to think carefully about the policies they adopt so that incentives are not skewed towards one group or the other. While I've focused so far today on speech-related advocacy work, the division has many other mechanisms for promoting the discussion of pro-competitive policies. Our business review letter process might, in one sense, be viewed as a mechanism to share our policies on competition. While a business review letter is, of course, a statement of our enforcement intentions with respect to the particular arrangement described in that request, others in the antitrust community often look to these letters for insight about prospective enforcement views. It is in that context that I include our business review letters as a facet of our advocacy function. And as many of you know, the Antitrust Division has had a number of occasions to opine on issues of antitrust and IP through the business review process over the years. The division also represents the Department of Justice on the administration's Trade Policy Staff Committee. And in that context, we engage with other executive branch agencies to discuss issues at the intersection of antitrust and IP in an effort to ensure that the promotion of competition and innovation are key considerations in trade-related actions taken by the United States government. A fourth facet of our competition advocacy, which I'm excited to mention, is our recent effort to expand our amicus program to increase our participation in private litigation, not only in the United States Supreme Court when invited, but in the district and appellate courts as well. While this effort is certainly not limited to issues involving the interface between antitrust and IP, I can envision these issues attracting our interest as amicus, given their relevance to our mission in promoting competition. Having described in more detail our advocacy role, let me turn to the division's role as an antitrust enforcer. As I've said previously, in the context of antitrust and IP, we will be inclined to investigate and enforce when we see evidence of collusive conduct undertaken for the purposes of fixing prices or excluding particular competitors or products. So what type of conduct in particular might attract enforcement scrutiny? In the context of standard setting, cases like radiant burners, hydro level, and Allied 2 provide helpful guidance regarding the kinds of collusive conduct that naturally would garner our attention. They're particularly helpful in illuminating our concern about situations in which competitors either corrupt the standard-setting process so that decisions are not made by a balanced group of IP holders and implementers, or where competitors reach anti-competitive agreements outside of the scope of a legitimate standard-setting exercise with detrimental effect on competition. Let me describe two related situations that would raise concerns in the context of voluntary consensus standards development. First, if a group of patent implementers were to engage in concerted efforts to exclude a patent holder from meaningful participation in the standard setting, unless the patent holder agreed to offer particular terms dictated by the group of implementers, those facts would raise red flags. Similarly, if patent holders A, B, and C were to agree to exclude from consideration for inclusion substitute technology owned by their competitor patent holder D for the purpose of harming the patent holder, rather than as a result of good faith efforts to incorporate the most effective technology, that would also raise concerns. While I believe in a very restrained approach to antitrust enforcement when it comes to the legitimate exploitation of valid IP rights, the division will not hesitate to enforce against anti-competitive collusive conduct, particularly in an area as high stakes for the American consumer as this one. Over the years, the division has made efforts to ensure that the advocacy positions we take are not misconstrued by the public. For example, when the division issued the 2007 IP report, we in the Federal Trade Commission included in the chapter on patent pools arrangements through which multiple patent owners collaborate to offer a single license to a package of their patents, a description of certain safeguards that patent pool participants had put into place in various arrangements submitted to the division for business review to ensure the efficiency would be enhanced and that potential competitive harm would be mitigated. We were careful to note, however, that although the safeguards we described were a basis upon which we articulated our intention not to bring enforcement actions, quote, in an enforcement investigation examining a patent pool, failure to incorporate all the safeguards set forth in the pooling business review letters would not automatically lead to the conclusion that a pool is anti-competitive. We stated that we would instead evaluate the particular facts and circumstances to determine whether the actual conduct has an anti-competitive effect. I point out the distinction between advocacy and enforcement and the division's efforts to highlight it because I believe there are some risks associated with conflating the two. First, it can be the case that advocacy positions lead to unsupportable or even detrimental legal theories when taken out of context. As I explained at Penn, as a result of past speeches and position statements about patent holdup that may have been intended to be limited to a context of competition advocacy, I worry that putative licensees have been emboldened to stretch antitrust theories beyond their rightful application, and that courts have sometimes indulged in those theories at the risk of undermining patent holders' incentives to participate in standard setting at all. Another risk of conflating these advocacy positions with enforcement intentions is that industry leadership in standard setting could be stifled or undermined if business leaders are concerned that each decision they make will be called into question by antitrust enforcers in the United States or abroad in the context of an investigation. That is why our statements regarding antitrust and IP aim to clarify what conditions are ideal, and at the opposite end of the spectrum, what conduct might attract enforcement scrutiny. As a prior division official, my old colleague Jerry Masudi said about 10 years ago, and I quote, "The great strength of the competitive marketplace is its ability to experiment, recover from false starts, and seek an efficient equilibrium through an organic development process. We should not expect to be able to predict where the best ideas will come from, but with all respect to my colleagues in the enforcement community, I doubt they will be developed entirely from the top down by antitrust enforcers in the United States or elsewhere," end quote. While the division will not hesitate to advocate for the conditions that are most likely to attract robust participation in standard setting, we want standard setting bodies to be industry-led, and we encourage them to experiment, to compete with one another, and to be creative. This is a point we have supported making to foreign governments in the trade context, something I'll be talking more about in the coming months. With respect to the difference between advocacy and enforcement, a final point I want to make is how important it is for foreign enforcers to be aware of our two distinct roles. Recently, I've noticed that some of the division's work, including business review letters, has been cited to support foreign enforcement actions that we would not bring under United States antitrust law. For example, while the division decided that it would not challenge as unlawful the IEEE's patent policy update in 2015, including the portion of the policy that limits the availability of injunctions to holders of FRAND-encumbered patents. For the reasons I have just explained, this letter should never be cited for the proposition that what IEEE did is required, or that a patent holder who seeks an injunction is somehow in violation of the antitrust laws. On the topic of international enforcement in the antitrust and IP context, let me make a few additional points. As I highlighted at Penn, as enforcers, we have an obligation to ensure that antitrust policy remains sound, so that consumers enjoy the benefits of dynamic competition, and also so that we do not export unsound theories of antitrust liability abroad, where dubious enforcement actions would have harmful effects here in the United States. In pursuit of that ideal, we strive to be disciplined in our own analysis and enforcement procedures, not only because it is the right thing to do, but also because we want to lead the way as enforcers around the world grapple with the issues presented by today's high-tech markets. For example, when we look at IP-related conduct, we do not simply assume that a patent confers market power. Even where market power may exist, we focus our analysis on the actual competitive effects of the conduct at issue. This was not always our approach. In the 1970s, U.S. antitrust law took a skeptical view of patent licensing out of concern that the exclusive rights of a patent might be leveraged into monopolies over unpatented products, causing harm to consumers. As former Assistant Attorney General Rick Rule has written, quote, "Fear that the patentee would exercise market power and harm consumers of the product overwhelm recognition of the benefits that dynamism spurred by patents could create for all consumers." Over time, we came to understand the importance of dynamic competition, and that is a principle we want to share with our foreign enforcer colleagues. We also strive to impose remedies that are carefully tailored to the harm we identify, whether in the context of a conduct or a merger investigation, requiring remedies that go beyond that scope, particularly when those remedies relate to the exploitation of IP rights, risks unnecessarily undermining innovation incentives. With respect to remedies, we also give careful consideration to territorial scope, and we urge our enforcer colleagues to do the same. As Deputy Assistant Attorney General Roger Alford explained earlier this year in Korea, quote, "In a world of concurrent authority, it behooves us to recognize that conduct we condemn abroad may affect international commerce and impact the power of other nations to grant rights to their subjects and regulate conduct within the scope of their authority." Finally, we adhere to sound and transparent enforcement procedures, because doing so is a fundamental part of operating according to the rule of law, and also because providing parties with opportunities to test our evidence and to push back on our legal theories helps us refine our thinking. This ultimately allows us to reach the right substantive conclusions. As we engage with our foreign counterparts on this topic, we are considering some innovations of our own regarding how we and other jurisdictions might increase our mutual commitments to that principle. Ultimately, it is the people in this room who work for some of the most innovative companies in our country and the world who will enable the next great technological leap. My responsibility is first to ensure we don't implement policies that unduly limit your incentives, and second, to leverage actively all of the tools at the division's disposal to ensure that you're motivated and able to thrive in a market-based economy. As part of that responsibility, I want to ensure that our policies and enforcement intentions are clear and well understood, so that you can proceed with the business of developing the next generation of technology for the benefit of all of us. I also want to ensure that our enforcement intentions are clear to our enforcer colleagues outside the United States, given the interconnectedness of the world when it comes to high technology. Thank you very much for inviting me to speak today. It's been a great pleasure. I'm happy to take a couple of questions if you would like, to the extent I can speak on those topics. Thank you.
Christopher Yu from the University of Pennsylvania. I want to thank you for gracing us with the remarks that you gave at Penn and for allowing it to publish your remarks in our new Journal of Law and Innovation. You gave us a hint of it here, but I'm wondering if you could amplify more on what you said, which is you said the real father of intellectual property is usually thought of as Jefferson. It's really Madison. And you said there's some real lessons we can take from that. And I was wondering, since we didn't have a chance to share it here, I was wondering if you could at least give a flavor of that to the audience here today.
Sure. Well, I mean, for those of you who might be bored, feel free to read those comments. But basically, in a nutshell, what I meant by that was that even though we have antitrust laws for 125 years and we're one of the older agencies, they've been on the books since 1890s. The patent laws were actually in the Constitution about 100 years before that. And there was a lot of debate. There was some fascinating discussions between Thomas Jefferson, who was a little bit more dubious, and all of them somehow were very suspicious of monopolies because of the way they were handled by the king. And so, however, the debate between them, which was fascinating in the letters exchanged, was that, hey, when we're dealing with the creative arts and the sciences, it is legitimate to allow for limited monopolies, as evil as monopolies could be. So technically, they recognized antitrust principles way back then, but it was Madison who really pushed back on Thomas Jefferson to recognize Article 1, Section 8 in the Constitution. And my hope is that we rebalance that, and unless Congress directs us otherwise, which sometimes they have a tendency to do those things that may not be sound. But our role is to make sure that we respect validly enacted patent laws.
Thank you very much. Thank you very much. And I think I counted dynamic competition 4 times, and I was delighted. And I read your other speeches, and you mentioned it many times as well. You didn't mention static competition, which of course is, in my view, what the agencies have in the past too often practiced. What does this really mean? Does it really mean that in the spirit of Schumpeter, we're putting innovation first for the first time, rather than just a tag along as it's been in the past? Can you give us a little bit more flavor on what you mean by dynamic competition and how much of a pivot is this for our public policy?
Thanks for the question. I don't know if this is for the first time. There have been different times, and I think just like as we have observed by interpretations in the courts, there's a pendulum that swings every now and then. I think we learned probably in the early 80s the values of economics-based understanding the application of the antitrust laws and the effects-based tests that we have, and the benefits that we've come to realize from whether it's a field of use, restrictions in a patent license that actually allow for greater efficiency for exploiting the rights, and the more value you can extract from those, the greater your incentive is to invest. Ultimately, that's really the goal of the free market system, and we don't want to discourage that. I don't think, I think on the edges, different people and different economic theories pop up every now and then from very respected people. And what's great is that this debate is being had. So there were folks who kind of looked, took a snapshot. Wouldn't it be great if you didn't do this practice and the price went down 5%, 10%? It's a little bit short-sighted because you're doing this at the risk of the long-term benefits. And I think ultimately that's what we mean and what others mean by dynamic competition. It's a heck of a lot better for the consumer, for you to have the incentives to invest in that next, the paradigm-shifting innovation in the car technology, rather than, it's a heck of a lot better to have the new whatever Tesla and the technologies of that is being promised by them in self-driving auto, rather than an extra $5,000 cheaper on the Chevy Malibu that might be today's state-of-the-art technology. So we want to recognize those types of benefits, and it goes throughout I think in all areas of the arts.
Thank you, Attorney General Delrahim, and I abbreviate your title slightly, not by accident, but out of a sense of hopefulness for the leadership that you're giving our country and hopefully will in the future. Thank you for articulating this new balance as between the important antitrust system and the intellectual property system. It's beyond a breath of fresh air, and it points a direction that is conferring tremendous hopefulness on people who care about innovation outcomes for our country. My question is as follows. As a fellow patent attorney, you know, like many of us in this room know, that patents don't confer monopolies. Patents are a negative right that confer an opportunity to exclude others from doing things. It's beyond unusual that a patent confers a monopoly, and for those few patents that do wind up having value in the marketplace, of course, they've got all the other attributes of being temporary. My question is, we have this terrible conflation of folks confusing patents with grants of monopoly, both in the US and abroad. And I wonder if you could talk a little bit more about what we need to do as a community, how the people in this room help you, and how we work together to educate our own public in the US and the global enforcement community, that patents aren't about grants of monopolies. They're about enhancements to competition, and they're about dynamic competition.
Thank you, Director Kapos. I think, let me give you a quick example that shows kind of where we have seen some encouraging signs in certain areas of the world. In 2003, 4, when I had the privilege of serving at the division, I made a handful of trips to China as they were drafting their anti-monopoly law. And I believe it was one trip in Shanghai. I remember it because it was so startling. One of the folks who was helping draft their anti-monopoly law said that, you know, that earlier draft, if you do not license your competitor in a patent, you would be violating the antitrust law because you're limiting competition in that product. Fast forward 13, 14 years later, a couple of months ago in Beijing, that wasn't the view of a lot of the questions at the embassy where I was speaking. I think a lot of folks have come to recognize, partly because they have now benefited from the values of intellectual property as their economy has developed, and seen the benefits of having a robust IP system. Now, obviously, there's some challenges, but the movement from where they were before to where they are now, and the continued education that folks have provided there. I gave the example, I said, you know, I take, like probably many folks, statins. I take a drug, you know, Lipitor or whatever it is, just because, and at the time Lipitor was under patent protection. It makes no sense that Lipitor, as a patented drug, has any market power. At the time, there was Mevacor and there was simvastatin, and you had 6 or 7 different statins that were all interchangeable and have similar. Just because you were able to obtain a patent on that does not. And those real life examples made people understand. I was in Europe talking about, just recently, last month, in Brussels, about SCPs, and I was asked to describe my views at USC. They said, well, these are so controversial, how could that not be? And once you give real-world examples about dynamic competition, I think people begin to understand where we're coming from. So the abstract concept, legal concept or economic concept, is a lot more difficult to quickly grasp, whereas that static snapshot is a lot easier to grasp, and people benefit from that who advocate for those positions. But to the extent we can have real-life examples showing other foreign enforcers as well as judges here in the United States, more people will appreciate it and understand it, because I don't think up for much debate that dynamic competition benefits the U.S. consumer much better than static competition does.
Hi, my name is Andreas Stargard. My question relates to the one element that you mentioned towards the end, which is your leadership internationally, providing guidance and sort of setting examples to other enforcement agencies abroad. And what I have seen in my practice is that abroad, especially in more developing and more recent additions to the antitrust jurisdictions internationally, they have included certain, some might call them protectionist, some might call them public interest provisions in their antitrust laws. What is your opinion on that? I guess I can guess what it is, but I would like you to say it. And then also, related to that, the recent intervention in terms of, for instance, the Broadcom proposal, the Broadcom deal, how do you see the role of the DOJ antitrust division being an example internationally, in that sense that your leadership is now setting the tone for non-intervention by political forces versus pure antitrust law?
Well, first, let me just say that, intervention through the antitrust laws for protectionist measures is just bad. They should not do it. It's not good for anybody involved. Neither is really a legal standard of the public interest test. I mean, I think, frankly, a lot of those should be unconstitutional under the non-delegation doctrine, but we'll leave that to other folks or experts in that world. But I think the public interest test, as you see, as leadership changes, what the heck does that mean? It becomes whatever you want it to mean at that time. And I think in antitrust, that's a horrible standard because it doesn't provide businesses with that certainty and the objective tests that we've come to rely on. So I don't know. I know there's been some advocacy about having some kind of a public interest test for mergers and for antitrust law in general. I think that would be misguided. To the extent anybody asks my opinion, I'll advise them of that in the proper process. You always have, just speaking in generality, you always have national security holdbacks in international trade agreements in other area that that could trump other policies. So to the extent various policies are exercised in the interest of national security, there are avenues through which you address that, and antitrust is not that. Antitrust is not and should not be that. And so when foreign governments do that, I don't think it's wise. And some of the efforts which we will talk about in the next couple of months is to have certain commitments by a group of leaders in the international community on the enforcement side to commit to certain procedural safeguards and make sure that elements of international law that everybody has come to know since the GATT agreement of most favored nations or national treatment are something that we can respect within the antitrust enforcement regime internationally. Thank you again, Jim, for the invitation, and to all you guys for what you guys do to continue to advance the thought in this important field.